matter. This is my third time arguing this same issue before this court. And Judge Thomas, I want you to bear with me. I think you sat on the panel on the first two, and you're going to hear a lot of the same arguments all over again. In this case, it's very straightforward. ofYisell Cabrera, at age 23, was catastrophically injured in a car accident and died the next day. Medicaid paid for her medical care. Her surviving two parents brought a wrongful death claim, which settled for the insurance policy limits of $140,000. ACA asserted a Medicaid lien against the settlement, and the personal representative of ofYisell's estate brought an administrative proceeding under Section 409.910, paragraph 17B, to challenge the Medicaid lien at DOA. After a full-blown final hearing evidentiary trial, the matter was submitted to the administrative law judge. The agency filed a proposed final order of dismissal, requesting that the matter be dismissed because the Medicaid recipient was dead, and according to them, dead Medicaid recipients can't challenge Medicaid liens in the administrative hearings process. The judge agreed and dismissed the case because the Medicaid recipient was dead and the administrative procedure under 17B wasn't available. That decision was issued before this court issued the Delgado versus Agency for Healthcare Administration and the Albatha versus Agency for Healthcare Administration decisions. That decision was wrong because there's nothing in the plain language of 409.910 17B requiring that a Medicaid recipient be alive in order to challenge the Medicaid lien, or precluding a dead Medicaid recipient from challenging the Medicaid lien. This court in the Delgado, and then again in the Albatha decisions, Albatha was issued last year and Delgado was issued the year before, clearly announced that dead Medicaid recipients may challenge the Medicaid lien because their cause of action does not die with them, and under the Florida law, the personal representative of a deceased person is the proper party to bring that proceeding. So this court has ruled that under 17B, a deceased Medicaid recipient, through their personal representative, may challenge the payment of a Medicaid lien asserted against a wrongful death settlement.
Well, you know, the argument here is slightly different. So it's whether or not the 2017 statute with the triggering phrase changes that result. I know you've got a couple arguments in your excellent brief about that. And so, if you don't mind, would you focus on why that introductory clause doesn't make this case different?
Thank you. I was waiting for someone to interrupt me and say, we've heard this all before, Floyd. In 2017, the statute was amended to add an introductory clause that says if federal law limits the agency's recovery, then the Medicaid recipient may challenge the lien. The reason, well, first let me point out one thing, what the legislature didn't do. The legislature did not say anything about dead Medicaid recipients or requirements.
It doesn't say anything like that.
Exactly.
But it does say, essentially, Medicaid, ACA can recover if allowed by federal law.
It says,
I don't think you agree with that description of the clause, but that's what it seems to say, is unless barred by federal law, and the anti-lien statute refers only to living recipients.
Well, thank you. But it doesn't say, the 17B doesn't mention the anti-lien statute, it says federal law. And the anti-lien statute isn't the sole basis of ACA's recovery being limited.
Right, you rely on the anti-recovery federal law.
And the limited assignment of the Medicaid recipient's right to recover medical expenses, which is the narrow exception to both the anti-lien and the anti-recovery provisions. And this is sort of the fundamental misunderstanding by the agency. It's highlighted in their answer brief. Repeatedly they say the anti-lien statute limits the agency's recovery. The U.S. Supreme Court in Auburn only looked at the anti-lien statute, and that's not true. The U.S. Supreme Court looked at the limited assignment. They said that under federal law, states may recover based on a limited assignment of the Medicaid recipient's right to recover medical expenses. And then they looked at the anti-lien statute and the anti-recovery statute. U.S. Supreme Court in Auburn quoted it. And they noted that the anti-lien statute would prohibit recovery. But they also noted in footnote number 13, they said likewise, the anti-recovery provision in 1396P, paragraph B, would appear to ban even any recovery, period. But because that statute hasn't been cited, we'll save that for another day. They went on to outline that the anti-lien statute is a complete bar to recovery, with the only limited exception being the assignment of the Medicaid recipient's right to recover. Only the Medicaid recipient is required to assign to the state their right to recover medical expenses. Other parties are not required to assign their rights, their causes of action, their individual damages. And that's important because in a wrongful death case in Florida, the estate has a claim to recover medical expenses and funeral expenses, and the survivors, in this case the parents, have a right to recover their individual damages for the loss of their child, for mental suffering and pain and anguish, etc., etc. The courts in Florida have identified that these are individual claims brought up by the personal representative, and the individual claim for the parents is their private property. The parents in this case, parents in all cases, don't assign their rights to the state to recover. Under federal law, only the Medicaid recipient is required to assign their rights. Now, with that being said, that's a limitation in recovery that bars the agency's recovery when the person is dead. But more importantly, the anti-recovery provision, which is one subsection below the anti-lien provision, clearly states no recovery may be made, period. It's a complete bar to recovery, just like the anti-lien statute, of equal importance to the anti-lien statute, and it doesn't have any limitation such as prior to death. So when the Florida legislature says that if federal law limits the agency's recovery, then the agency or the Medicaid recipient may challenge the lien. Federal law limits the agency's recovery regardless of whether the Medicaid recipient is dead or alive. Very easy statutory interpretation. That's the plain language. And I want to point out one last point. The change to the 2017 legislature was not changing the statute, section 409-910, paragraph 17B, to prohibit deceased Medicaid recipients from challenging the Medicaid lien. That was not their intent. Their intent was to change the law in anticipation of a change in federal law that was slated to take effect October 1st, 2017, which would have permitted the agency to recover from all portions of a settlement, medical expenses, pain and suffering, and the like. That change in federal law never took effect because it was repealed by Congress in February 2018. The purpose for the 2017 legislature changing the statute was anticipation of that change. It wasn't to preclude deceased Medicaid recipients from challenging Medicaid liens, which this court has recognized in the Delgado and Albatha decisions. If the Florida legislature intended to take away a Medicaid recipient's right to challenge the lien, they could have clearly stated that in the statute by just adding a few simple words, such as living Medicaid recipient or a precluding dead Medicaid recipients from making the challenge.
Well, your argument is that even if the Florida legislature had done that, it would not be allowed under federal law.
Well,
I mean,
yes.
that's not a problem for you necessarily, but that your argument based on the federal law is that the Florida legislature could not do that. Isn't that correct?
Oh, yes, we would be arguing that, absolutely.
So if they had passed a statute and said deceased Medicaid recipients have no right to challenge any clawback whatsoever, the argument would simply be that's not permissible under federal law, right?
That's right. That would be my argument, absolutely. But fortunately, I don't have to make that
You
argument.
don't have to get there,
Right.
is your argument.
Because the statute doesn't state that dead Medicaid recipients in Florida can't challenge the lien. And federal law, when you look at all provisions of federal law, prohibit recovery regardless of whether the recipient is dead or alive. I think I'm into my rebuttal.
Thank you, Counsel.
Thank you.
Good morning. May it please the court. Alexander R. Bowler on behalf of the Agency for Healthcare Administration. Counsel for the appellant talked about the Delgado and Albatha decisions that this court made previously. Those two decisions say that a Medicaid recipient's personal representative may bring the claim in DOA to reduce a Medicaid lien through this subsection 17B procedure.
Counsel, why aren't those decisions applicable to the facts of this case?
Those are not applicable to this case because they were made under the old version of the statute, the 2013 version of the statute. It has since been amended, as Mr. Fagley explained, to add a triggering clause that requires first federal law to limit ACA's recovery, then allows a Medicaid recipient or a Medicaid recipient's legal representative to challenge the Medicaid lien. Federal law does not here limit the agency's recovery because the anti-lien statute has a clause in it that means that it applies only prior to the death of the Medicaid recipient. And the anti-recovery statute does not have the same meaning as the anti-lien statute. And so let me talk about the anti-recovery statute first. The anti-recovery statute, the Supreme Court expressly disclaims as the basis for their decision in Alborn, and it's not mentioned in the follow-up decision, Voss. It's only briefly mentioned in Alborn, and it's not the basis of that decision, and then it's not the basis of the Florida Supreme Court's decision in Garcon. It's not the basis of this court's decision in Harrell. And it's not the basis of any decision by any Florida DCA applying the Alborn and Voss line of cases to Florida Medicaid law. What the anti-recovery statute actually means, I will say, is admittedly a little vague. But I want to start with the amendments that were taking place under federal law to the federal scheme. Counsel for the appellant explained, both in his brief and here at oral arguments, that there was going to be a change that was going to take place in 2017, which would have allowed Medicaid to recover all of its Medicaid lien without limitation to the medical expense portion of the settlement. Well, the language of that change does nothing to the anti-recovery statute. It leaves it exactly as it is. It just changes the anti-lien statute. So if a change to the anti-lien statute and leaving the anti-recovery statute alone will eliminate a Medicaid recipient's right to challenge a Medicaid lien, then we can't say that the anti-recovery statute has the same effect as the anti-lien statute.
What does the anti-recovery statute mean in your view?
The fourth DCA addressed that issue in a case, Gohegan versus Perkins, although they only touched on the issue very briefly. They explained that it meant that a Medicaid program may not recover more than what it had paid out.
Is that the agency's view of the statute?
That's one option. I honestly do not know what the anti-recovery statute should mean, but we can look to the forced assignment provision, which is 1396 little k a and 1396 little k b. This is one of the provisions that requires a state Medicaid program to have in effect laws that assign a Medicaid recipient's rights to the agency. And there, in 1396 little kb, any amount collected through that assignment is to be held by the state program to, quote, reimburse it for what it has paid out. And in section 1396 little A25B, the state Medicaid program is tasked to seek reimbursement for what it has paid out. Both of these provisions, which require the state program to go after money that has been made available from a liable third party, use the term reimburse to refer to what it has, what that money does to the state program. Recovery is a different word which would have a different meaning. The term recovery is often used when the Medicaid program is going back and forth with medical providers, or the Medicaid program is going after assets from insurance companies through other programs, not going after the assets that have been recovered by a Medicaid recipient or a Medicaid recipient's.
So it's the agency's view that it's inapplicable?
It is inapplicable. It has a different meaning, and we can't assume them to have the same meaning.
But I mean, the argument by opposing counsel that the legislature could have specifically said a personal representative in a state can't maintain a claim in the 2017 change has some merit perhaps, right, when you consider what a substantial change this is. In other words, if a family, as in this case, suffers this kind of a loss and 60% of the recovery is pain and suffering, for example. We'll just use an example. Let's say the family recovers $1 million, which didn't occur here. The amount of insurance provided by the at-fault party, I mean, the amounts of insurance were shockingly low. But so let's say a family does recover $1 million, and 3/4 of that is for pain and suffering. You think the agency asserts the legislature meant to say, that's unfortunate, but we're going to take that money back because our medical bill is $600,000, even though that recovery was based on pain and suffering for the death of the child? That's a sea change, isn't it?
Not necessarily, Your Honor. The intent of the legislature was to reimburse the public coffers to the extent allowed by federal law. And it's important to recognize, especially in the context of a wrongful death case, that before any amount is allocated between the estate and the survivors, Florida law requires the agency's lien to be paid first. The agency's lien is on the recovery from that liable third party. It's not on the portion that goes into the estate. The third DCA and the fourth DCA recently, or 2015 recently, said that. And back in 2003, 4, 5, the second DCA said the same thing, concluding that the operation of the Florida Third Party Act takes place before operation of the Wrongful Death Act. And so ACCA's lien is on whatever comes from that third party first, before there's any amount for the survivors or for pain and suffering damages. And I would also like to touch on the limited assignment provision. The limited assignment provision is a floor to what ACCA's recovery is. It carves an exception to the anti-lien statute, where the anti-lien statute would prohibit a lien on a Medicaid recipient's recovery. Because the forced assignments for medical expenses, it carves an exception to that anti-lien statute. But just existing on its own, without reference to the anti-lien statute, it's only a floor as to what ACCA's amount of reimbursement should be. And so while federal law requires a low floor, the state may impose a higher amount that should be assigned to the state under state law. So
not applicable here.
So it's not applicable here as a reason that limits the agency.
How would that apply in the agency's view? How does that floor apply? Just give us an example.
It's not an effective floor, because the agency is allowed to set a higher standard. And then I just want to reiterate that if federal law is going, were to, I believe in the initial brief, the appellant says, destroy a Medicaid recipient's ability to contest a lien without touching the anti-recovery statute, then the anti-recovery statute can't have the same meaning as the anti-lien statute. If there's nothing further,
Could you repeat that last point, please?
Yes, Your Honor. In the appellant's initial brief, page 40-41, they explained that the change in federal law, which was going to take place in 2017 through the Bipartisan Budget Act of 2013, they explained that change would destroy a Medicaid recipient's ability to contest a Medicaid lien. But the text of that change does nothing to the anti-recovery statute. The text of that changes the anti-lien statute by adding, the anti-lien statute says...
So your argument is if Congress had meant to make these dramatic changes, they would have amended the anti-recovery statute?
If Congress believed the anti-recovery statute had that effect.
Right, then they would have done that, and they did not do that.
Correct. And so the anti-recovery statute cannot have that same meaning as the anti-lien statute.
But it's all impenetrable, as your brief notes. Several judges and courts have noted.
It is a mess to get through, and I admire your work on it. If there's nothing further, I'll yield and ask this court to affirm.
Thank you, counsel.
Thank you.
Well, I just want to make sure we're not confused on this. The 2017 legislature did not change 409.910(17)(b) to take away a deceased Medicaid recipient's right to challenge the Medicaid lien through their personal representative. If they had intended to do that, they would have stated that plainly in the statute. I want to point out in footnote 8 on page 21 of the answer brief, the agency shows great candor in pointing out that there's no legislative history concerning the amendment to section 409.9.
But why wouldn't a textualist approach require us to rule in favor of the appellee here? In other words, if you will, the Justice Scalia approach to reading statutes, which urges courts, now Florida Supreme Court has said we do look to legislative history, so that issue is alive in Florida. But so if we don't have legislative history and the text says, essentially unless limited by federal law, the agency can file a lien against the amounts of any person and a deceased person cannot challenge it, why shouldn't we read it that way?
Well, without legislative history, we don't have to get there. Look at the plain language of the statute.
Right.
It doesn't preclude deceased Medicaid recipients from challenging.
But it references a federal law that references living recipients.
Oh, heading out pretty far there. But it references federal law.
I know, I'm not going to ask you to concede that, since you're relying on the anti-recovery statute, but the Florida statute says, essentially, if allowed by federal law, the agency can can place a lien on these amounts, and the federal law says living recipients can contest certain amounts.
Well, I think maybe if the statute said if the anti-lien statute limits the agency's recovery, but it says if federal law limits the agency's recovery. And there's a lot more than just the anti-lien statute. There's the assignment provision that limits the agency's recovery to the Medicaid recipient's assignment of their rights. There's no provision requiring the parents to assign their rights to the agency. And then there's the anti-recovery provision, which the agency says that limits us to only the amount we've paid. But that's not what the anti-recovery statute says. It says no recovery may be made, period. There's nothing there to support the agency's view. Now the agency says, well, that does the same thing as the anti-lien statute, so it can't be duplicative. That's not what the Third Circuit Court of Appeals in Tristani said. The Third Circuit Court of Appeals in Tristani looked at the anti-lien statute and said it barred a lien. They looked at the anti-recovery statute and it says it bars recovery regardless of the mechanism of recovery. It's a broader prohibition of recovery. And then they went on to say the assignment and reimbursement provisions of federal law are best viewed as creating an implied exception to the anti-lien and anti-recovery provisions, thus permitting the agency to recover based on that limited assignment only. Now, the agency mentions that no one talks about the anti-recovery statute. No one mentions that, but the Third Circuit did. The U.S. Supreme Court, in footnote 13 of its Allborn decision, acknowledged it and said, likewise, the anti-recovery provision would ban any recovery. The Fourth District Court of Appeals in Roberts versus Albertson talked about the Tristani and said, of equal importance is the anti-recovery statute. And this court has quoted the anti-recovery provision in the Geraldo versus Agency for Healthcare Administration decision when it explained that the anti-lien and anti-recovery provisions prohibit recovery. So yes, the courts are talking about the anti-recovery provision. It's not just the anti-lien provision. I'm out of time. Do y'all have any further questions?
I do.
Good. You may.
I'd like to ask you, what is your reading of that triggering clause?
Oh, which clause?
The triggering clause at issue here. How do you read it?
I read that provision to be a provision that was put in the statute in anticipation of a change in federal law
That did not occur.
that did not occur. And now it's there.
It's a dead letter in your view.
I think I think at this point in time, it just acknowledges that this provision 17B is there as a result of the various federal courts that have limited the agency's or Medicaid's recovery, which all the courts have said that 17B is there because federal law requires it to be there, in essence.
Kind of restating the supremacy clause?
It is, it's putting it in the statute for the first time because previously the statute didn't make much reference to federal law whatsoever, for whatever it's worth. But no, I don't think it has much meaning since President Trump signed the 2018 budget deal that repealed that change in federal law. So,
Counsel, assume for the sake of argument that we agree with you. In terms of the amendment, how do we get around the federal anti-lien and the recovery statutes?
how do you get around it? The federal anti-lien and anti-recovery statutes prohibit any recovery, with the only narrow exception being the Medicaid recipient's limited assignment of his right to recover medical expenses, which the U.S. Supreme Court and other courts have all said permits the agency to recover from only the portion of the settlement representing past medical expenses. Status quo, wrongful death cases are treated the same as personal injury cases, and we keep doing what we've been doing under Albatha and Delgado. Status quo.
Thank you.
Thank you.
This concludes our oral arguments for this morning. Stand adjourned.